Good morning, everyone. My name is Eric Glazer. I help lead physician engagement and social media here at Best Doctors. And our topic today is a real interesting one. It's one of our most requested topics since we started this webinar series. And ironically, it's the first one we've covered without any physicians as a speaker or a panelist. It's entitled A Legal Perspective, Why Physicians Should Be Using Social Media. And I am joined by healthcare expert and social media expert and attorney David Harlow, who I'll formally introduce in just a moment. If we do our job successfully this morning, at the end of the hour, you'll have a good high-level understanding on how doctors could leverage different digital communication tools inside and outside the hospital without dramatically increasing risks associated with malpractice and or HIPAA. Today's session is being recorded and it will be available on demand following the completion of the webinar. For those of you who have not heard of Best Doctors before this webinar, I just want to quickly clarify what we do. We were founded back in 1989 by two physicians at Harvard Medical School with the purpose of supporting doctors in identifying the right diagnosis and the right treatment for their patients. In other words, we provide very detailed medical advice. We don't sell advertising. We don't ask doctors to pay to be parts of our company or part of our Best Doctors in America list that we're often known for. We create that Best Doctors in America list through a peer-reviewed peer polling process that is audited by Gallup, where physicians actually identify colleagues in their specialty that they believe are the leading physicians in their work. And we use those voted upon and elected experts in those specialties to be part of our collaborative medical process and provide expert medical consultation to our clients. What we do is we employ a collaborative process and we take some of the best medical minds in the world and we put them in this collaborative process to harness the best medical minds in getting the right diagnosis and right treatment. We subscribe to sort of the quote by Charles Darwin that in a long history of humankind, those who learn to collaborate most effectively have prevailed. Our business model is around supporting large employers and now health plans in helping their employees. So those employers and employees come to us when they need medical advice. They do not have to pay for that medical advice, their employer does. So we pay our bills from large Fortune 500 companies like Home Depot, Hertz, and others. I just want to briefly explain how we conduct our medical analytical process, how we actually provide that medical advice that I just alluded to, and it'll give you an idea of how we combine sort of the medical minds and how we produce what we do, and then we'll jump right into some of the questions that we wanted to address around today's topic. An employee of one of our clients who's sick will call us. We will take a full patient intake over the phone with a seasoned RN on the other line. We will then collect all their medical records and, if necessary, rerun their pathology and re-review the radiology. We then have one of our internists, who's a full-time practicing fellow at a leading teaching hospital somewhere in the U.S. They will take all that information and synthesize it into what we call a clinical summary. This is a 4 to 12-page overview of the case with associated medical records and medical and diagnostic images that are important to the case. We make that nice and succinct. We outline we identify key questions that need to be answered about the case, and then we take another team of nurses who help specialize in case matching with our Best Doctors in America database with the case profile. We match the case with an expert or sometimes experts, and we provide them with this clinical summary. And then the experts review the clinical summary, address the questions that we've put in front of them, and help us confirm or change the diagnosis and or treatment of that patient. We call that patient a member of ours because they represent the population base that we cover as a healthcare benefit to those large employers that I alluded to just earlier. So as technology has evolved, opportunities to further grow and enhance our medical process has been put in front of us. Digital technology and social communication tools that enable a more holistic approach to case reviews, a more holistic approach to doctors looking at a particular medical question, also enabling better communication between doctors and certainly better communication between doctors and their patients. All this is coming to physicians very quickly, fast, and furiously. We just launched our own online platform that enables us to conduct cases more efficiently. Any best doctors on the call today can request sort of a demonstration on how they could take advantage of that platform. It's open to all of our best doctors who want to use it. So it's a free service and a free platform that you could use. And at the end of today's session, we'll put up a little feedback form that'll take 2 or 3 minutes to complete, and you can request access or a demo to that platform. But what we want to do today, and what we're committed to doing, is educating the medical community on the value of social media, how to take advantage of all these various platforms out there, make sense of all of it, and make sure we're addressing your questions. This is probably the 6th webinar that we've covered specifically addressing social media per se, and each one prior to this webinar, questions have come up around the legal ramifications and the legal risks that a doctor may have if they jump onto Twitter, if they jump onto an online community, if they start blogging. So we have brought in one of the leading experts in the space, David Harlow, to help clarify some of the questions that all of you may have on this topic. David is a frequent speaker and publisher in the area of healthcare and social media. Prior to just jumping into social media and becoming an expert in the space, he was a partner at a couple of private law practices in downtown Boston, and also served as the Deputy General Counsel of the Massachusetts Department of Public Health. So he has an incredible range of experience and perspectives. We're very excited to have him here with us today and look forward to hearing all of the insights he may have. And everyone on the phone, very open to interrupting David with questions as he brings up topics. So use the Q&A module to your right to type in a question. We'll be monitoring the Q&A queue, and as questions come up and if they're relevant to where David is in his presentation, I'll interrupt him and I'll make sure your questions get asked during the flow of today's session. And if we can't fit it in within the flow of David's presentation, and certainly in the last 10-15 minutes of today's hour, we have allotted to taking more Q&A. So we'll definitely get your questions addressed today. So with that, David, I'm gonna hand it off to you. Thank you for being here early this morning, and we look forward to your presentation.
Thank you very much. Thank you very much, Eric. I appreciate your all being here early this morning, and I know the idea of listening to a lawyer speak at this hour may give you some agita, but I'll open with a joke. So how do you save a drowning lawyer? You take your foot off his neck. So I hope that helps you listen to a lawyer at this hour of the morning, where I'm going to be speaking to you about some of the reasons why healthcare providers should be using social media and how you can do so without getting into trouble. So we'll start with this cartoon that's about 20 years old. On the internet, nobody knows you're a dog. And this old cartoon really reflects an internet ethos of an earlier time, anonymity. But today, flamers and trolls aside, there's really a decided preference for owning one's own online presence, particularly in the realm of social media. There are some anonymous bloggers, but for the most part, since authenticity is the name of the game, anonymity is out. Through most of human history, we've shared information through word of mouth. And the 19th and 20th centuries, in a sense, were really a blip on the course of history, where we enjoyed mass media as a means of communication. But the power of mass media is now on the wane. We have hyper-specialized and socialized channels of mass media. We're really going back to word of mouth, and sometimes we're going back to the hyper-local, like in my neck of the woods in Massachusetts, where we have online local newspapers which are referred to as wicked local. That's the Boston way of talking about something that's very local, wicked local. So you need confidence to use social media despite these potential legal issues, and patients and caregivers and potential referral sources and so many other human beings, frankly, are all online. So healthcare providers need to be online as well, engaged in social media. If you're not there, you're missing out on an important part of today's conversation. And as I'll address later on, there are regulatory pressures nudging you in that direction as well. There are about 20% of the hospitals in the United States who are using social media, okay? Approximately 1,200 or so out of 6,000 hospitals are using social media through a variety of media. YouTube channels, Twitter accounts, Facebook pages, LinkedIn accounts, Foursquare, blogs, and the numbers continue to grow. But nevertheless, it's important to note that it's still an opportunity to be an early adopter. We're talking about 20% penetration among hospitals, similar numbers among physicians. There are a lot of numbers published that say virtually all physicians in the U.S. are using social media, and that may be true, but thus far you are not using social media at that level for professional purposes. I'm here today to tell you that you can use social media effectively and stay on the right side of the law. Now, how is that? You need to think clearly about your goals. You need to figure out very concretely just what it is you're going to do to achieve those goals, and you need to focus on those goals and on staying out of trouble. Bottom line, this requires some advanced planning. So let's take a look at Facebook Nation here. It's the largest nation, third largest nation in the world. If you look at this chart of Google search volume over the past number of years, you see that rolling along the bottom there is global warming, very low volume. The red line just above that is search volume for sex, which is also not that great, but has maintained a certain consistency over the years. And the orange line that sort of breaks into the stratosphere in mid-2008 is Facebook. That's Google search volume for Facebook. And it's just one indication of the power of social media and the volume with which it is pursued by so many people online. On any given day, people share over 830 million items on Facebook, upload over 6 million photos to Flickr, add over 2 million minutes of video to YouTube, and send over 65 million tweets. So every 2 days now, we create as much information as we did from the dawn of civilization up until 2003. It is critical to be able to focus folks onto some of this information because there's a huge amount of information out there. And as we know, a lot of it is misinformation and disinformation. So social media is your way of connecting people who you want to reach with good information, whether it's written by you or curated by you. This is the way to do it. Social media, of course, is not the be-all and end-all. It's one arrow in the quiver, but it is a key arrow to use in achieving the articulated triple aim of healthcare, providing high-quality care to ensure population health at a reasonable cost. This requires integration, and it requires patient-centeredness, and that is really key, the notion of patient-centeredness, and we'll come back to this in a moment. So is social media really right for healthcare? This here is the conversation prism. It's just a way of looking at the different social media channels out there and thinking about how different platforms are useful for different sorts of communications. And why is social media useful for healthcare? Because people are flocking online to find and share health information using a whole variety of these tools. And what exactly are people doing online in the realm of healthcare? Well, a couple of studies that are repeated annually done by the Edelman Digital Health Practice, called the Edelman Health Engagement Barometer, and the Pew Center for American Life and the Internet releases a study each year performed by Susanna Fox and her staff. The Pew Research study, the Edelman Health Engagement Barometer, and other sources tell us that half to two-thirds of all adults in the U.S. are looking online for health information. Not all of them are going to Google or other search engines. So the point is, you need to be online in order to be found, in order to be a trusted resource. And the social aspect of this is taken a step further, because more than half of all searches are done on behalf of someone else. So there's the social aspect online, and there's the social aspect offline as well. Over half of people expect healthcare providers to be educating the public on health topics. Over half expect healthcare providers to help folks lead healthier lives, and over half of folks expect healthcare providers to support the health of local communities. And using social media to address these issues will show that to your constituencies that you are meeting their needs and doing what they expect of you in basically a low-cost way. You need to think of social media, though, as a power tool. And if you don't know how to use the tool properly, you can get hurt. Internal social media tools within a network may be used to engage clinicians in the work of a network, whether you're talking about a small physician practice or a large interdisciplinary group or integrated network. You can have secure collaboration within and across sites, both for clinical consultations, curbside consults, and also more formal collaboration, for business communication, for education internally and externally, and for research. These social tools are extremely useful in all of these realms. And even we can even transfer to the social realm a little friendly competition among colleagues on quality metrics, and that's always proven to be good for everyone. As I said before, there's some regulatory reasons why clinicians should be using social media, and there are rules moving us in the direction of getting more social. For example, under the Accountable Care Organization rules, which affect federal ACOs for Medicare, and these are mirrored in the private sector by commercial ACO rules initiated by the private payers and institutionalized by NCQA, there's a tremendous push in the direction of patient-centeredness and patient engagement. And at the federal level, at least, it's important to note that while patient-centeredness is a cornerstone of ACO development and other issues under health reform, the rules are not prescriptive, they're flexible, and there are different ways to achieve patient-centeredness. And social media is certainly a way to communicate with patients in a patient-centered way, meeting patients where they are, where they want to be. Under meaningful use, electronic health records now include patient portals, personal health records, and communication through that mode as well. In the realm of value-based purchasing, there are opportunities for care management through social media, which can have the effect of lowering costs and improving quality of care, and therefore improving reimbursement to healthcare providers under value-based purchasing initiatives at the Medicare and commercial levels. So there's a whole range of reasons why social media tools should be used. not only from the perspective of improving communications, but from these regulatory and reimbursement perspectives as well. And it is a powerful care management tool. If folks receive messages in the channels that they use on a daily basis, they're more likely to be open to take action as a result of these messages. And people have seen this in all sorts of realms, ranging from the Text for Baby initiative and other text-based initiatives started by the federal government and others, and also in the realm of one-on-one communications through Facebook and other channels between patients and physicians. Now, we'll get to this a little bit later. Not everybody believes you should be friending patients, but if you are dealing with an adolescent patient population who live their lives on Facebook, it is going to be beneficial to engage with them on Facebook, because that's where you can make the most difference in their health status. So I understand there's a culture clash. There's a real culture clash here, and we need to acknowledge that up front and address it. And in order to do so within your organizations, you need to convene appropriate groups to develop relevant policies and procedures so that your approach to the use of social media can be consistent with the rest of your organizational culture. The medical establishment is getting wise to social media. So it took a little while, but a couple of years ago, the American Medical Association even adopted a policy on professionalism in the use of social media. And it's refreshingly commonsensical. Most elements simply represent the extension of existing norms into the social media space. Don't post identifiable patient information online. Safeguard physician personal privacy online, understanding that anything you post may be online indefinitely. Consider separating personal and professional profiles online. One portion of the policy, though, could potentially impose some significant obligations on individual physicians who are active in social media. When doctors see content posted by colleagues that appears to be unprofessional, they have a responsibility to bring that content to the attention of the other physician so he or she can remove it or take other appropriate actions. And if that's not done, you need to bring that to the attention of the appropriate authorities. This is not different from what you're supposed to be doing, quote unquote, in the real world, but it is an additional obligation to take on in the online space. And we'll see how this works out over time. Other bastions of other sources are also encouraging the use of social media. The Veterans Administration is very forward-thinking in this arena, as they have been in the use of electronic health records. So there's a VA social media policy, and the use of web-based collaboration tools are highly encouraged. The issue that comes up is, how do you balance authentic interaction versus legal liability? And the way to do that is to develop the right consensus document within the broader rules that we have to live with so as to enable authentic interaction. Now, this little handy-dandy flowchart on how to respond to a comment online was developed by the Air Force on a policy on commenting on a blog post. There's always the question of legal liability, and healthcare providers need to balance that with their desire for authentic interactions with patients and prospective patients. Of course we want to have authentic interaction. Who wouldn't? Just need to go about it carefully in order to avoid liability. Now, clinical leadership and other leadership may fear losing control of the message if you open up to social media, and this is in addition to privacy concerns. Traditional managers may find social media to be too open, and people live in fear of losing control of the message. But bottom line, folks, you've already lost control of your message, and stopping your ears and ignoring that fact is not going to be helpful. People want to engage. We need to meet people where they are. We need to speak their language. It makes sense, and as I said before, now it's the law. Patient engagement and patient-centeredness requirements. We need to ensure that the platforms for conversations are in place. The hardware, the software, the human capital, the policies and procedures developed through an inclusive process. And what do I mean by that? It should not just be policies and procedures for use of social media in your group or institution developed by a group of executives sitting around the table. You should include social media users throughout the organization in this process. Folks who are excited about this stuff and who can help communicate the rules informally once they're adopted. It's important to open up the process in order to make sure that it works effectively. So sharpen your pencils, folks, now. Put on the green eye shade and put yourself in the shoes of the most risk-averse folks you know within your organizations and practices, because you need to internalize that perspective in order to identify, avoid, and manage risk. Okay, number one, HIPAA. A patient can release his or her own private information, protected health information, but nobody else can without consent. If you violate the letter of the law and disclose or use information in ways you should not, you're going to be liable to the federal government, fines, otherwise. State attorneys general can file suit under the HITECH Act, and under state law there may be liability to patients as well for violating confidentiality. And remember, patient claims that go to court will be heard by a jury. So, common law liability involves a duty that one party has to another party, a breach of that duty, harm to the second party, and a causal link between the breach of the duty and the harm. For example, a physician has a duty to provide services according to a standard of care. If she provides lesser services and her patient is injured as a result, that's malpractice. Similarly, common law breach of privacy, the same analysis would apply in the privacy realm. There's no private right of action under HIPAA, but a government finding that a covered entity inappropriately released protected health information may be used as a breach of duty of care in a private lawsuit. It depends on state law, but that is something to consider and keep in mind as a potential risk. So, patients and potential patients, referral sources, regulatory bodies will be judging you, or a jury of your peers. Think about what policies and procedures you want to have on the books and fully implemented before you end up on trial in front of a jury that perhaps may be made up entirely of 20-something Facebook users who are online 24/7. You need to be ready to deal with folks in this brave new world.
Hey, David, just a quick interjection.
Sure.
Folks, as David's going through some of these details, if you have questions, again, a reminder, the Q&A module on the right-hand side of your screen is where you could submit them, and we'll try to take them as they come in. Go ahead, David. Sorry.
Thanks, Eric. You can limit liability by defining roles and responsibilities in policies and procedures. You need to get patient consent where relevant, and you want to be updating your notice of privacy practices under HIPAA to address the way in which you're using social media, how you're using it, the degree of privacy that may be expected. You want to also include, for example, notice that it should not be used for emergencies. Channels are not being monitored 24/7. And critically here, the notice of privacy practices and your actual internal policies and procedures really ought to be consistent. And remember, even the very fact that a patient-provider relationship exists is itself PHI, protected health information.
Hey, so David, here's a question right on point with that. And the question is, what do I need to include in my bio on my blog or Twitter to limit my liability? Are there specific words that you could advise physicians on what they need to include?
Sure. I mean, a simple, this is not medical advice goes a long way. So that is sort of the bare minimum. But there's sort of a broader set of policies and procedures that you want to think about adopting. And that's really going to depend on where you are on the continuum of institutional and personal comfort with social media. So, for example, what I mean by that is somebody just starting out in social media is really in a different place than an organization like, for example, the Mayo Clinic that's been doing this for years on an institutional level. And so your own social media policy is likely to evolve over time as your comfort level and experience level with social media evolves over time. And I usually recommend to folks that you revisit policies like that every 6 months.
Are there specific, for an individual physician who's just sort of jumping into social media, let's say this is their first year into social media, and this is the follow-up question that I'll ask on behalf of the audience, is there specific verbiage that is used, or is there examples of specific verbiage that other doctors are used or that you've advised physicians that need to be included? Because obviously, maybe not so much for someone who has their own blog, but certainly for someone who's using Twitter, there's obviously a limited amount of characters that they could put in their bio. So what are the key terms that have to be in there? I mean, no medical advice is a good one. Are there other key terms that have to be put in there, or there's really nothing in the bio that could really just fundamentally keep the doctor in a certain sort of range or a certain safe harbor, I suppose?
Right. I think the two key concepts to put across in the situation you describe is really conveying this is not medical advice, and a physician-patient relationship is created only when you come into my office and you become a patient in my practice. So, two things. It's not medical advice and you're not my patient simply by virtue of being on my, reading my tweets, etc. There are other situations where an existing patient may pose a question to a physician via Facebook. And again, to jump ahead to the Facebook question, I would recommend that people have a practice page where somebody can be a fan rather than using a personal page where someone ends up being a friend on Facebook.
Right.
So that people can be receiving information, but there isn't that same kind of connection that you would have with close personal friends and family through Facebook. For most situations, that's not going to be appropriate for physicians to do.
Is there a disclaimer, or is there some case law precedent that just because you're interacting with someone on a Facebook fan page or you're interacting with someone directly on Twitter that doesn't mean there's a doctor-patient relationship? I mean, clearly they could be in different states. I mean, there's obviously practice guidelines there, or is it just really important for the doctor to stay away from treatment advice?
Yeah, you don't want to be providing treatment advice unless you're talking to an established patient. And if you're talking to an established patient, I would suggest that you be in some sort of more private communication setting. You can take the conversation out of the public setting and into a private messaging setting, even on Facebook or even on Twitter. But that must be done with the patient's consent, and that's what I was talking about a moment ago in terms of policies and procedures and notices of privacy practices. If this is going to become an integral part of your practice, you want to let patients know that these are the tools that you're using and that you're using things that are going to be at an appropriate level of privacy and security, and that they're going to consent to using channels as, for example, I consent myself to using channels that may not be 100% HIPAA compliant, but if I consent, if I waive the privacy, I, the patient, waive the privacy protection, then my clinician is going to be okay using plain old vanilla email in communicating with me. So it is up to the patient to decide, and as physicians, you shouldn't be deciding for your patients what's the most appropriate channel. You need to make that something that the patient gets to decide.
Great, thanks. Any other questions? You could certainly, the Q&A module is right there to your right. Thanks, David.
And one of the challenges of using a whole variety of modes of communication is that for continuity of care and other reasons, we want to have these communications ending up in the electronic health record if you're using one. So that is the benefit of using a secure email portal. Those messages that are going through a personal health record portal will end up linked to the electronic health record, so that information is there for the clinician at a later time, or for a colleague, or someone who's a specialist to see later on. If it's private email or tweets, it's going to get lost. So let's talk about a couple of examples of social media use gone awry in healthcare, because the case studies we will look at, we can see what went wrong, or in some cases what went right, and learn from that. So the case studies really boil down to the case of too much information. That's really what they're all about. No matter what the platform, there will always be some people who want to use these platforms and some who don't, and you need to have your arms around all these potential uses and abuses before they happen. So a couple of Facebook-based examples to start us off with. Somebody posts on your Facebook page, I'm cancer-free 1 year post-treatment after getting a test result. Or someone posts an emergency communication. Or someone posts on Facebook a prescription refill request. So how do you respond to those? As I was saying before, you want to have terms and conditions of engagement posted on Facebook, and you can set up tabs on a Facebook page, and your terms and conditions should be prominent, and maybe that should be the landing page on your Facebook the first time a new quote-unquote fan lands on your Facebook page and subscribes. You want to have somebody scrubbing the page for inappropriate content on a daily basis. And there are a couple of tools that can be used to help you do that and sort of screen for particular words that you might want to keep off of a public Facebook. If you get positive feedback, that's great. What about if it's negative feedback, a negative patient experience, or other sorts of negative feedback? You need to think about, what do you write back? How do you write back? Who responds? How do you respond? These are all things that need to be addressed up front before these things happen in a set of policies and procedures. I want to give one sort of cautionary tale of a physician in Rhode Island who, after a rough day in the emergency room and losing a patient, posted on a personal Facebook page about the experience without any identifying information about the patient. There are 18 factors under HIPAA that need to be stripped out of any patient record in order for it to be considered de-identified. And what happened is that the detail about this patient was able to be re-identified through other information online. As I said before, thanks to the multiplicity of sources and huge amount of information that's available online, sometimes what we think is private is really not. What we think is de-identified is really not. It can be re-identified from another source. So anyway, this physician ended up being sanctioned by the Board of Registration in Medicine and losing privileges at a hospital because of a Facebook post about a patient that didn't mention the patient's name. So my point there is not to scare you off Facebook entirely, but just to make clear that there are certain rules and regulations and restrictions within which you need to operate. Some Twitter examples. There's a case of a politician seen at a clinic when it was closed to the public, and an employee tweeted about it. She was outraged that the clinic was staffed up for the convenience of the politician. She lost her job because she was tweeting about protected health information of an individual and using his name. So you need to be careful how you segregate your personal views, your political views, and your work life. That is something that could come back to haunt the institution and supervising clinicians as well. So it's important to orient folks to these policies and procedures. It's nice to have them in a binder, but it's more important to have them be living documents communicated by people who live and breathe social media to the rest of your staff. People have been known to tweet, "I've been sitting in this waiting room for hours." Again, if you're not on social media, you're never going to see that message, and it's important to be able to see that message so that you can do something about it in the real world. Send somebody down to the waiting room, find that person, explain what's going on, and sometimes you can turn your harshest critics into your greatest goodwill ambassadors, really building some brand equity for your practice and operations as well. Now, blogging. If a patient blogs, we're talking about that patient's own protected health information being released by the patient, so that's really not an issue. It's up to the patient. Providers blog, and protected health information really may not be released in that context. You really need to carefully de-identify your patients. And some physician bloggers always blog about composite patients or about fictional patients, or sort of take a lesson from one patient and transpose it into someone with different characteristics, so that there isn't an opportunity for re-identification of that de-identified patient. Now, as I said before, if someone puts their mind to it, PHI can be identified. The de-identified record can be re-identified. So it is very important to do that carefully if you're going to be blogging. Photo and video sharing also need to be addressed with internal and external facing policies. Even instructional photos of procedures are sometimes posted with too much information. A physician name and affiliation could be used to back into a patient ID. And so you need to have policies in place and enforced regarding photography. Someone can post a photo or a video from their own cell phone, and if an inappropriate image is included, it'll end up being your problem. So you don't want to have people posting cell phone photos from your waiting room, which could have an image in the background of something inappropriate. Try to harness YouTube as a medium for your message. Viral video can be incredibly powerful, but you don't want to get a negative experience out of hand on a YouTube video. I don't know if folks on the line have heard of the United Breaks Guitars videos on YouTube. Over 11 million views last time I checked. If you're not familiar, check it out on YouTube, United Breaks Guitars. It's about an ignored customer complaint that resulted in tremendous negative PR for the company. And people, it is very easy for someone to shoot and post a video on YouTube, and you just need to be that much more careful about how you deal with people, because the negative repercussions as well as the positive repercussions of social media are tremendously powerful. So we need to understand issues beyond HIPAA. Social media cuts across all areas of the law. We think of it as something new now, but in the future it's just part of the general background environment within which we operate. And so these issues are not just centered on privacy. An employer's social media gag rule. This is something that came up in a union sort of dispute, but the rules apply beyond unions, okay? Protected concerted activity is an employee right under the National Labor Relations Act that protects employees from employer retaliation for discussing working conditions. So that applies to union and non-union employees, and the Act provides employees the right to associate together to improve working conditions, etc. So you want to be careful about having a social media use policy that is too restrictive on the question of what employees may discuss about working conditions. Social media can be used for recruitment, and you just need to respect boundaries. There's a time and place for everything. It means, for example, online you don't want to be posting job listings in a forum that's set aside for substantive discussions. There are ways and appropriate forums for doing that. Federal Trade Commission endorsement disclosure rules cover social media explicitly. So you don't want to have anonymous positive reviews posted by employees or friends on rating sites. You don't want to have plugs by bloggers without disclosure of any arrangement of financial compensation or goods and services. That is, doing that is considered an unfair and deceptive business practice and can lead to sanctions from the Federal Trade Commission, believe it or not. If you're part of a 501c3 tax-exempt organization, you don't want to be getting into political endorsements on an institutional blog or Twitter account or a YouTube channel. That can have dire consequences for the organization. In the old days, the IRS's only thing the IRS could do was revoke your tax-exempt status, which they almost never did. But nowadays, they have the ability to impose what are called intermediate sanctions, also known as hefty fines. So you want to be careful about that if you are associated with a tax-exempt organization.
Hey, David, I just want to address a couple of requests that have come in. Earlier in the presentation, you mentioned sort of the 18 factors that need to be adopted for patient cases to meet HIPAA de-identified standards. They're online. We'll find them for everyone online, and we'll send you either a link or just a screenshot of the 18 and send them out to everyone as follow-up with David's slides if you request it at the end of today's presentation. So we'll get those to you if you want them, but I just wanted to address those requests right now since they've been coming in. Go ahead, David.
So, I mean, they're mostly common sense things. It's sort of, name, address, social security number, gender, et cetera. But the thing that a lot of folks don't know is that the 18th category of what needs to be redacted reads something like this. It's anything else that can be used to re-identify a de-identified record. And based on the volume of data that gets added to our collective knowledge online on a daily basis, it becomes easier and easier over time to re-identify a de-identified record. So that's just something to be very much aware of.
Sure. So I mean, I don't want to throw you off course too much, but since those requests were coming in, maybe I'll ask a follow-up question on behalf of everyone, because that Facebook anecdote probably got a few folks nervous. What were the specific one or two things that you're aware of that this physician, one or two of those 18 that this physician did not follow when expressing himself on his Facebook page about that case that got him in trouble?
Yeah, it really was the number 18, and that's the difficulty. That's what I want to point out here. So it was a small community, and there were news reports about the accident that led to this patient's death. The patient's name wasn't in the news report either, but people were able to put two and two together and figure out who the individual was.
Got it.
So maybe that's the small town exception here at work. Mm-hmm. In a big city, it might not have been as easy to put two and two together. But again, over time, it becomes possible to sort of triangulate the identity of an individual patient based on a variety of online sources. And there have been a number of articles written about this in general, not just in the context of healthcare, where there's so much information about all of us online that with a little effort, it's sort of possible to find out more about each of us than we probably are comfortable with. So at a certain level, we just have to sort of come to terms with the fact that all that info is out there. But from the HIPAA perspective, we need to keep in mind that we don't want to be the source of that last nail in the coffin, so to speak, of privacy. So Again, on the blogging front, that's why a lot of physician bloggers use composite stories, so they stay away from the danger. On the other end of the spectrum, it is possible and advisable in some cases to get consent of a patient to blog about their story. And if you get that patient release, then you're that's your get out of jail free card, so to speak. That means you don't have to worry about these issues if you have an appropriate patient consent to discuss this. Now, some patients will be very interested in having you discuss their cases online if, for example, they're dealing with a rare disease and want to know that the search for information is going as far and as wide as possible. So, again, for some patients, the pressure is in the opposite direction. I want to be as open as possible versus I want to be as private as possible. But you need to have that conversation with the patient before you do something like that. The other point here, this slide about intellectual property rights, it seems like a simple thing to clip and use video, music, photos, other stuff online and use it in your blog, etc. It's important to make sure that you have appropriate intellectual property rights unless you fit within an exception, like parody. There's some popular hospital videos on YouTube that are parodies of popular songs, and you don't need permission from the rights holders to publish a real parody. Again, you want to be explicit about uses of protected health information. There's Patients Like Me is an online patient community where information can be shared, and Nielsen, the ratings agency, actually created a fake patient profile to get into the site and scrape information which they should not have been doing, and they were exposed. They figured it out pretty quickly. Now, Patients Like Me sells access to a backdoor, a key to a backdoor, so to speak, for a fee to organizations like Nielsen or pharma companies. And that's legitimate. That's what makes the site free for patients. And the problem here was not the sharing of the information, but the way in which it was accessed through deceit. And Patients Like Me came out okay out of this incident because their terms and conditions were real clear and understood by their patients and members up front. Foursquare is a location-based social media tool where you can quote-unquote check in. Users can share tips on locations, including your practice location. It's useful to get active here so you can activate your fans to leave tips about your services. But you can also get into trouble. I don't think you're going to get into trouble in terms of kickback rules if you give somebody coffee for checking in, something like that. But you don't want to necessarily encourage people to check in at your, Center for Skin Diseases. That's going to show up on my Twitter and on my Facebook. I'm not really interested in publicizing that. But you need to know your public because some folks are interested in publicizing that. There was a very successful campaign a few years ago getting tested for STDs. MTV, the music cable network, had an I've Been Tested badge campaign via Foursquare. So people were actually checking in on Foursquare to announce that they're being tested for STDs. And through the power of that social media, encouraging friends to do the same thing. Retail coupons, Groupons, there are a whole host of issues based on kickback fees for referrals, insurance problems, but Groupon is very valuable for certain kinds of services and something that may bear examination for your particular practice or particular services within your practice. So where are we going? We're getting to the point where there are more and more external reasons to engage in social media. The sharing and curation are important and powerful uses. The patient engagement and patient-centered care or part of the law. You can build something like Virgin Health Miles, health promotion, incentives, teams, weight loss, diet and exercise, all on an opt-in basis with disclosures for patient groups, for employee groups. And there are a whole host of examples of ways in which you can tie social media to wellness and health improvement, as well as the communication of curated health resources. And I want to emphasize that people can join the vanguard by being smart. My takeaway point for you today, folks, is that you can stay on the right side of the law. You want to stick to your guns. Respect the law, respect your constituencies, respect the power of the tools that you use, and think about the framework and the case studies we've looked at today. And in doing so, you can plan for the future. There's so much change going on in healthcare, and there will continue to be, and I think it's better for you to be ahead of the curve than playing catch-up, and I hope that some of the ideas that we've talked about today help put you ahead of the curve in using social media in your practices on a regular basis. And thank you for your attention.
David, that was terrific. Really interesting stuff. I know a lot of folks have been asking questions specifically about this. David, I really appreciate the time and effort this morning. Thank you, everyone, for taking the time to join us this morning, or those of you who are listening to this on demand. Thank you for taking the time to listen to this, and we'll continue to be producing webinars on topics that you recommend and suggest to us that are relevant to how you work and how you're adopting different communication channels as a physician.